and today I thought I'd go through with you one of the most fundamental things that anybody needs to have when they're drafting a will: testamentary capacity. Now, testamentary capacity essentially means, do you have the mind and the competency to actually draft a will and make sure you are sound enough to give the instructions to the person that you would normally give those instructions or inheritance to? Now, with that being said, testamentary capacity can essentially be given to anybody who is over the age of 18 years old. In fact, you are presumed to have testamentary capacity unless you are proven not to. Now, the key thing to remember is that lawyers, when you go to somebody to get a will drafted, they need to make sure that you do have the mental capacity to actually draft a will. Because if you don't, then the will is considered invalid, and then somebody might have to go to the court and treat it as if no will had been drafted, which is much more expensive and time consuming. Where we have the issues is when people can lose capacity permanently or temporarily. Permanently obviously refers to the unfortunate cases of dementia or Alzheimer's, but you can also lose it temporarily. Once again, if you suffer from Alzheimer's or dementia and the person has more of a elusive and clear mind in the morning, but they have the issues in the afternoon. We also might have people who fall temporarily into a coma, but they regain their consciousness and are still of sound mind. So how do you determine during those stages whether you are actually sound enough to make a will? Well, there's a court case for that called Banks and Goodfellow, which essentially says that you have testamentary capacity if you can understand exactly what a will is, if you understand what exactly you are gifting and who you are gifting it to, understanding that there are people who can challenge your wills and who can challenge it, and that you have no insane delusion that might be influencing your creation of the will. So if your reasoning for drafting a will and you say to somebody is because the devils have told you that, I don't know, your sister-in-law is trying to come and kill you, well, then that might be considered an insane delusion and you've lost your testamentary capacity. Now, who determines who has your testamentary capacity is obviously the lawyers who we've talked about. However, if the lawyer suspects that you do not have testamentary capacity, what they will do is they will send you to your general GP or a doctor. The doctor will then do some tests to determine whether you are of testamentary capacity or not, and that doctor may provide a letter, then they should be required to provide a letter saying yes, this person is of sound mind, or no, they have now lost their testamentary capacity and they cannot draft a will, and their enduring power of attorney may have to come into effect. Now, if the person does not have testamentary capacity at the time that they want to draft a will, then what will occur is that somebody needs to make an application on behalf of that potential will maker to have the court involved to draft the will, or any type of previous will that was drafted by that will maker gets followed and enforced instead. It is so important to ensure that you have a will in place before you lose your testamentary capacity, because it is just much more expensive and time consuming to deal with an estate when there is no will or valid will in place. So if you would like to have your will drafted or updated, then please feel free to contact the team at NB Property Law. Thank you.